We'll let them in. All right, everybody. Thanks again for joining our new edition of Coffee Talk. What we're doing this edition is discussing Constitution and bylaws, probably one of the most requested information that I get from phone calls or emails from you. We've got Aaron Edelman from the IFF, who's the General Counsel's office, handles a lot of the big Constitution and bylaw questions. And so today we're going to be discussing a few topics. We're going to be very conscientious of the General Counsel's time, try to keep it to about an hour if we can, about a half-hour presentation to go over some topics. Those topics are going to include retirees, best practices for electronic meetings, electronic voting, which we did change some of the manuals recently. Also talk about election notifications, and then open it up for some questions that you guys may have. So without further ado, we're going to go ahead and turn it over to Aaron. And Aaron, thank you again for joining us, and take it away.
Yeah, thanks so much, DVPO. It's great to be with all you all today. And already I'm seeing a message about needing to talk about bylaws. So that is one of the things we're definitely, here for. As DVP Gilman mentioned, the things I'm going to focus on, for my presentation are retirees, virtual meetings, electronic voting, election notices. We'll open it up to questions afterwards. Questions can be about these topics, and we can also talk about other Constitution and bylaw issues you may have. Although I'm not going to be able to review your Constitution and bylaw right now in this meeting and give you an up or down right here. So on retirees, at the 57th convention in Boston, the delegates just adopted Resolution 33, which does three main things. It strongly encourages affiliates to consider including active retirees, but it recognizes local autonomy and doesn't change anything about the way locals handle this for things like setting conditions for having active retiree members, dealing with the dues, voting rights, and restrictions on holding office, and then directs the IFF to do more to educate affiliates, including, putting out educational material on the subject about active retirees. The IFF has over 34,000 active retirees across all 50 states, the 8 Canadian provinces, and Washington, D.C. Article 3, Section 2 of the IFF Constitution and Bylaws says IFF members who have retired from their respective local unions may be allowed to return at the local's choosing within a time period specified for eligibility for active retiree membership under the local's Constitution and Bylaw. Also, I don't know how widespread this is used outside of the legal department or in DC, we're certainly calling Constitution and bylaws CBLs all the time. So if I just start saying CBL, I don't want people to be confused that I'm speaking a foreign language. So then Article 3, Section 3 of the sample CBL that we give out to locals has this optional model language that says members who have retired from this local or have otherwise withdrawn as members in good standing may be allowed to return to this local within, and then there's a blank spot to fill in the specified time period as active retired members. So that's been the standard default model language for quite some time. And there are a number of locals that have it written like that. And if you do choose to have that model language exactly as written, what that does is it brings the active retirees into your membership. They're paying the standard half per capita, and they have the same rights at the local level as active members, except because they're outside of the bargaining unit, they don't have votes on things related to the collective bargaining agreement, your MOU or your CBA if you have one. So if that arrangement is good for your local, that that model language is perfectly fine. There's no need to change it. And there are a number of locals that choose to have it that way. But to be clear, it's not legally required to have active retirees have almost exactly the same rights as active members, because there's a legal terminology, active in the trade. That's the distinction. If you're active in the trade and you're an active member, you deserve the rights of active members. If you're not active in the trade and you're retired, courts have over the years understood that there is a distinction, and so that unions are allowed to treat retiree members, a little differently and to impose certain restrictions if they vote on those things and put them in their constitution and bylaws. So,
Aaron, and
yeah.
I hate to interrupt, and I don't know if you're going to go over it, and I don't want to cut you off, but can you go over some of those restrictions? Because I think it's pretty important to some of these people that are starting to consider retirees, things of the nature like not voting on MOU contracts, not running for office, some of those restrictions that you can hold on members. You can either treat them like a full member or you can restrict them. And how much can you restrict them?
Yeah, that perfectly segues right into, so this is the new model language that we have and that we can share with everybody, that addresses these restrictions. So it says active retiree members in good standing shall have the right to attend any meeting and to participate in such meeting in accordance with the recognized rules set forth in the manual parliamentary procedure adopted by this local. That should be familiar to people. That's your standard meeting participation language for all members. Then it says active retirees shall not have the right to vote for collective agreements. And then there's a semicolon. And the way we've drafted this model language is as sort of a pick and choose, that your local could choose about which ones of these restrictions you would want to put on active retirees. So you could say active retirees shall not have the right to vote for collective agreements and not have the right to run for office or delegate or alternate positions for the local. You could put a restriction on active retirees saying they can't vote for officers or delegates for alternates for the local. Or you could even go as far as saying that active retirees can't vote on any matter except for those matters that affect exclusively active retirees. So those are sort of the tiers of restrictions. And you can pick and choose among those things, and we have that model language available. But it's up to the autonomy of the local to decide what kind of participation is appropriate for active retirees and how the local would feel comfortable saying, well, we hadn't admitted active retirees before. We certainly don't want them to dominate the union, but we like having the ability for them to have a connection with the union as long as they're not running for office, or as long as they're not voting for officers, or as long as they're only voting on business that relates to active retirees.
And can you cover, because I have an interesting one the other day, and I want to make sure that, because it's not the first question like this that I received. You had a member that was getting terminated from a department on a local.
Mhm.
The member in good standing with that local. So he's withdrawing from the member in good standing, being terminated from the department. He's being
Yeah.
separated essentially. So he
Right.
can still come in as a member in good standing as a retiree, correct?
Yeah, I mean, that is the specific language, right, of of active retirees is, members who have retired from their respective locals or otherwise withdrawn in good standing may return as active
Yeah.
retirees.
Because I think that confuses a lot of people with the termination. Like, yeah, you're not great standing with your department, but with your local, you're still, considered a member in good standing.
Yes.
So,
So yeah, as I mentioned, if you include active retirees, they pay 1/2 per capita. Those dues come from each active retiree and are just submitted with your per capita submission. Um, I was just double checking with the GST's office about the update for October 1. So I saw we're at 1959. So it'd be half of that for active retirees. Another piece to consider on this is, because these rates change, you may want to consider including language, and we're happy to work with you, pass-through language, so that way the dues change in, coordination with international, or you could also add your state dues, right? So dues will be 1% of a firefighter, at this level, and in addition, IFF per capita, or, state per capita. So I can answer this question in the chat here.
perfect. That's what I was going to ask.
Sure. So the question is, if an active retiree comes to convention as a duly elected delegate alternate from their local, are there any restrictions the IFF has or plans to have in place on their ability to participate as a delegate or alternate due to their active retiree status versus full duty member? There are no restrictions right now. I'm not aware of anything on that, right? If you're a delegate from a local, you're a delegate. If you're duly elected, you're a delegate. If you, as long like so, um, if a local chooses to restrict and say retirees can't serve as alternates or delegates, then that retiree couldn't be elected. But if the retiree, I mean, there are locals that have active retirees right now. I'm not aware, of what their status has been or if any of them have been elected to alternate or delegate status. But my understanding is they would be credentialed as having been elected in a valid way by their membership and seated and voting as such. Hopefully that answers that question.
Any more questions on retirees?
And then I don't know, I guess I know I was talking about pass-through dues. I don't know if anyone
Yeah.
had any questions about working with pass-through due list language. I'm definitely happy to work with anybody if anyone has.
And when we send out the link for the recording, what I'll do is I'll work with Aaron and include text with the model language of the various topics we're discussing so that everybody here has that, or all the officers have that as we move forward. Because some of that is in the manual, some of it is in previous communications, but I'll make sure that we have the language as well.
Let's see. I saw we just got a question that said, could a promoted BC be considered an other withdraw in good standing? I think we would have to look at figuring out how the membership works, and what the membership categories are at your local. Have I frozen?
Nope, you're good. Oh, you did freeze. We'll give him a second, guys.
I'm sorry if I keep freezing here.
Oh, no, you're back on.
Okay. All right. I was just going to answer that question about what happens if someone gets promoted out of the bargaining unit. I think we would want to look at what the language is in your constitution and bylaws. I know in the past, there had been some locals that tried to create a category of membership called associate members that's not recognized by the IFF. We're trying to, make sure that that isn't done. But there are options that where members that have been promoted out of the bargaining unit could potentially be considered active retirees based off of them no longer being like active in the trade as rank and file firefighters in the bargaining unit. So we can work with you on constitution and bylaw language if you have questions about that.
Aaron, if you don't mind, kind of go a little bit with that topic, because this is obviously with recent changes, we've had a ton of CBLs denied for membership. What are the only recognized membership levels that the IFF has, if you don't mind speaking?
Sure. The categories that the IFF recognizes are active retiree, and honorary. Right? Active full dues paying, active retiree, half per capita, honorary, no dues, no fees, no voting rights. Truly sort of an honorary capacity, right? Like, I mean, you can give it to members that have, that have, shown some exemplary commitment and want to retain a connection. I know it's also used for like, a way to recognize local officials. But those are the three categories. We'll see things like associate member, administrative member, sometimes it's hard to keep track of what these titles are, but they're not recognized, and we're sort of trying to crack down on that and make sure that only the recognized categories are there at locals.
Perfect.
Okay. I'll segue into virtual meetings. Article 13, Section 8 of the IFF Constitution addresses local union meetings and states that every member in good standing of a local union shall have the right to attend any meeting and participate in its deliberation and voting, subject, however, to such reasonable rules as the local shall establish pertaining to the conduct of its meetings. So we heard from locals across the country that started doing virtual meetings during the pandemic, that they were having positive experiences with it, and they wanted to update their CBLs to allow for virtual meetings, even when they were not required by law to not congregate in person. So to be clear, I think we mentioned that there is a best practices manual that's available to everybody, but to be clear, the fact that it says best practices does not mean that we are requiring any local to have virtual meetings. We're not even encouraging locals to have virtual meetings over what they believe. It's the entire thing is just a guidance document that says, if you do decide to have virtual meetings at your local, here are the best practices to make sure that while you're doing that, that you're, consistent with Article 13, Section 8 rights. So, for example, if a local, just said, oh, this seems really convenient, we'll switch to virtual meetings, but we'll do them as like a webinar style where it's just the executive board doing, putting out notices and just speaking, for the duration without questions or debate or votes on motions, obviously, right? That wouldn't really be a union meeting. That would just be like a press conference. So, there are things we went through. We looked at the IFF Constitution. We looked at Robert's Rules. We looked at other, procedural, guidance documents for parliamentary procedure that do advice on, how to hold these kind of virtual meetings in an orderly way and put together those guidance documents. I do, just returning to whether, your local should have a virtual meetings or not. I did want to flag part of the recent update was in response to what we'd heard from large locals about saying that it was either impossible or cost prohibitive for them to have virtual meetings. Encouraging us to look up how expensive it would be for Zoom to actually accommodate that many members, or to track quorum when, you just have to sort of keep clicking left in order to actually see who's there and who's dropped off. Privacy concerns about who's standing just off screen. So virtual meetings might not be right for every local, but if your local determines that holding virtual meetings is a good way to conduct business, the guidance manual is there for you. We have this model language, which says meetings may be conducted through use of internet meeting platforms designated by the local executive board that identify participants and those seeking recognition to speak, allow display the text of pending motions, and show the result of votes. Alternative means for participation for members who cannot participate in the meeting virtually will be provided. Electronic meetings shall be subject to rules adopted by the local, which shall supersede any conflicting rules in the parliamentary authority and not be in conflict with any provision of the international or local constitution and bylaws. And then the rest of that guidance document are sort of bullet point things that don't need to be incorporated into your constitution and bylaws, but that are, again, based on those guidance documents that we've reviewed and compiled about things to do with what the secretary could be doing, how you could be keeping track of members, how you handle, members that are disorderly in a Zoom context, things like that. I can tell you a fairly common question that we get from locals is asking if they adopt virtual meetings, does that mean they necessarily have to adopt electronic voting? And that's really a practical question that depends on your local, the size of the local, and how you do the meetings. A practical starting point is that, with Zoom, right, we can't all speak at the same time. So the calling for yays and nays and just sort of hearing which side is louder just doesn't work in this context. So if you have a small local that, we've worked with some folks like that and just written their constitution and bylaws to say, all right, all business over Zoom meetings has to be by unanimous consent or roll call votes. Again, right, it's one of those things of how IFF, we're all made up of all these locals of completely different sizes, right? I'm sure that sounds insane to a large local. So, if that would be too time consuming or unmanageable, it would likely mean that you'd have to look into, electronic voting to help you get through, routine business at union meetings.
Yeah, and I want to thank your office, Aaron, for working with us on that. I do have a second opinion letter on larger locals using it because, again, like he prefaced, we really didn't consider when we sent the original message out trying to negotiate a meeting with that many people on. This meeting only has 27 people. Our Social Security meeting had over 100. And when you get even over 100 and you're trying to track and who's raising a hand or who's got a question, and you start switching that or moving that to a parliamentary style parliamentary style meeting, it's virtually, no pun intended, impossible, right? It becomes too big of a chore to track and who's on. So for those of you that have large locals, that is something to consider if you're looking at virtual meetings, about whether or not it's going to be manageable. And again, when we started looking at some of the platforms that run, over 500 members to 1,000 members, then over 1,000, it gets very expensive as well. So there's some things to consider if you're in that boat, and I'm happy to share that information with you.
Again, sorry if I froze there. I'm not sure what part I cut off on. I know I was talking about voting on virtual meetings.
Yep.
If anyone had questions about that, I'm happy to answer those. Okay.
I don't see any hands raised. I think we're good.
All right. Well, so then we'll segue into electronic voting.
Okay.
For electronic voting on matters where a secret ballot is not required by the law or the IFF Constitution, we have model language that could be added to your Constitution and bylaw that just says, except for voting on any matter which requires a secret ballot, electronic voting may be used and shall contain sufficient encryption to ensure security and authenticity of the vote, a mechanism to ensure each member votes only once on each vote, maintaining the secrecy of the member's vote, password protection, the ability to calculate members' votes. Electronic voting shall only be accessible to members of the local, and an alternative way to vote shall be made available for members who choose not to use electronic voting. Sometimes we'll get asked why that language mentions secrecy when the votes aren't secret ballot votes. There's a difference between secrecy and privacy and the legal requirements of a secret ballot vote under the law. So the language in that case is designed as a practical consideration to prevent harassment of individual members of their votes, because if you were in the room together for a regular meeting, you'd have some sort of, anonymity or protection of just being a voice in the crowd saying aye or nay. You wouldn't have a permanent record of, Brother Jones voted aye on every single vote. But if your local really hates the idea, contact us. There might be some wiggle room on, approving Constitution and bylaw language, that doesn't use the word secrecy, which is something I mentioned to TVP Gilman I wanted to specifically address. At the IFF legal department, we don't want to make you miserable. We want to keep you protected, and we want to help you make sure you're complying with the law and the IFF Constitution. So if you get a note back and you're confused by it, there are certain things that are, that we can't be flexible on because it's the law or because the IFF Constitution is quite clear on it. For this example that I just gave here about this model language that we've developed about how to do, electronic voting on non-secret ballot matters, right? That's an example where I just said, well, that word about secrecy, we're hearing back from locals. It seems to bother some people. That one, I can't point to an exact specific thing in the IFF Constitution or the law. We've sort of done that as more of a best practices and kind of in keeping with how this kind of voting is done. And we can work with you because, again, there's a little flexibility. For votes where a secret ballot is required by the law or the IFF Constitution, there is different language, and the IFF legal department reviews it with more scrutiny because officer and delegate elections are regulated by the U.S. Department of Labor, and there are consequences for not getting an election right. The election might have to be rerun, possibly even under DOL supervision, or your delegates or alternates might not be able to be seated at IFF convention. So we don't mess around with that, and we do everything we can to make sure your elections are done right. Unions in the U.S. that include private sector workers are covered by the Labor Management Reporting and Disclosure Act of 1959, the LMRDA. And unions made up purely of state, local, or municipal employees are not covered by the LMRDA directly, but the IFF at the international level is, because we have affiliates that have private sector members. And so the international officer elections at IFF convention are strictly regulated by the U.S. Department of Labor. And then the way that trickles down to locals is that when locals elect officers and that serve as delegates to convention or directly elect delegates and alternates to convention, those things are regulated because those delegates are voting at the IFF convention, and those things must comply with the LMRDA, which is a conversation I've even had to have with French Canadian IFF locals about something called extraterritorial application, about why they are public sector locals at a in Canada that still have to comply. Let's see. So we got a question just for clarification. Can electronic voting be used for secret ballot items as long as CBL language is approved by the IFF? Yes, we have. I will not read you the entire text of that one like I have that one, but we have developed language. What this is building up to is we have developed model language that locals could vote and incorporate into their constitution and bylaws that say for secret ballot votes, we will do X, Y, and Z. And if you vote and adopt those, you could have electronic votes on secret ballot matters.
But for elections, Aaron, can you point out that we have approved platforms that specifically
Yes.
that we can only use? Because I think that's a big distinction that a lot of locals don't understand, is that we have very specific platforms that have been approved for elections of officers and delegates.
Yes. We just got it. Yes. And we also got a follow-up question that said, where is that language located? The language is located in the IFF Best Practices and Model Rules for Electronic Voting on Secret Ballot Matters guide. And I believe it's also included in a memo that we've circulated that has the list of the electronic vendors that have been vetted and approved for use for secret ballot elections, for electronic votes, which at this time, I can tell you that list is Ballot Point, Yes Elections, and Simply Voting Inc.
I dropped that in the
in
chat,
the chat.
the links.
Yeah, so I'm just pulling up the guide here. So it should be on pages 6 and the end of page 6 and the top of page 7. It's, the significance and why we updated this guide is because for about 10 years, the Department of Labor had this guidance material on how to do electronic voting for officer elections. They didn't say you couldn't do it, but it was almost impossible to do it. For all these years, there are 2 pieces of electronic voting. Secrecy, a member can never be connected to their vote, and observability, right? You have to have the ability for a neutral observer to come in and watch the distribution of the ballots and the counting of the votes. And DOL's position for almost 10 years, until they just updated it last December, was there's no way in electronic voting that they were comfortable with that you could do both. If you could do observability, then that meant that someone was able to see what a member's vote was. If you did secrecy, then that meant that no one would be able to properly observe it. In all this time, they had been working with people who understand technology a little bit better than the folks at the U.S. Department of Labor, and had been meeting with some of these companies that do electronic voting, unions, getting input from them, getting expert advice. And in December, on their way out, the Biden Department of Labor updated this guidance, and it's sort of for the first time, what it does is it creates a roadmap. It's not saying you can definitely do electronic voting and there's a guarantee that if you do this, you will always be, in the clear. They put some disclaimers on it, but what they say is, here is a bullet point list of things that we view favorably. And as long as you do these things with your election and you use a vendor that meets all those requirements, then it will be viewed favorably. And if someone challenges your election based on doing electronic voting, here, I've actually just put in the chat a direct link if folks want to look up the updated DOL guidance. But that is the full list, and you'll see it's also our guidance manual just mirrors a lot of the things in the DOL guidance. But it's basically just, if you do those things, you will, be in the strongest position to withstand a challenge to your election on the basis of having used electronic voting. And so in vetting those vendors, what we did was we literally took that checklist from DOL and just went through item by item and was like, can you assure us you're doing this? Can you assure us you're doing that? And these were the ones that gave the best answers.
And if you have platforms that you think meet the requirements, you can email them to me or to the IFF and they'll take a look at it. We've had several locals attempt to do that. That were kind of, nope, they don't meet it because of these reasons. But the IFF does consider other platforms. They just have to meet the stringent requirements required.
Yeah, we're always happy to talk to people, and we've talked to people more than once, we're happy to do that. I mean, we're really, we want to facilitate this. We just want to make sure that, it's, I'll tell you at least one of the vendors that we met with had sort of what I thought was an alarmingly cavalier attitude towards the law. And we don't want you to get saddled with that, right? I mean, because you're the ones that get on the hook with that if somebody challenges and said this wasn't done right. And there are costs associated with it. There are all these kinds of hassles that are associated with it. And, just while we're on that note, I do want to sort of flag, you'll see marketing material from vendors beyond the ones that we've approved that will say we're blessed by DOL or that we've survived scrutiny by DOL. At this point, I've talked to multiple enforcement officers from the Department of Labor. I also talked to the administrator for the Office of Labor Management Standards, the OLMS under Biden, which is the department within DOL that specifically deals with the LMRDA and officer elections and things like that. And they have told me that that kind of marketing is misleading because there has yet to be, what happens is DOL doesn't just go around the country preemptively just going randomly scrutinizing and saying like, we're worried about your election. It requires somebody to file a complaint. And then not only that, the complaint has to say, this is why I'm complaining. And then DOL investigates the specific things that were complained about. So if, for example, there was an electronic vote that was done and it was done badly using the wrong software and it didn't meet the standards, but the person complaining about it was only complaining about that the election notice wasn't sent out to the proper people or that union funds were used to promote an individual candidate, DOL will say, okay, this complaint came in, we've investigated, union funds were not used to promote a candidate. That's the only thing you complained about. So this election stands. They're not just separately going like, and wait a minute, what happened over here with this electronic voting? So what DOL specifically told me was a lot of marketing material that you will see from electronic voting is saying our stuff has been, has survived DOL scrutiny. And all DOL would say was, do not pay attention to that. It doesn't count for anything. They won't tell us, they certainly haven't formally approved anyone, and they won't even tell us of situations where they've handled it privately, where, there was electronic platforms that didn't withstand scrutiny. The only platform that we're aware of at this point that has failed publicly is the free website SurveyMonkey. So don't use that one. But when you just take one quick look at it, I think it would be obvious why you shouldn't use that one. But that is, that is basically where we're at with that, with having model language that can be adopted, having those vendors. We can do additional, we can meet with additional vendors if you ask us. And then just the change in model language, even if you all have electronic voting language in your constitution and bylaw that was approved before 2014, it may be worth reaching out to us just because we, during the pandemic and in the few years after that, we just heard from so many locals saying we really want to do electronic voting. And so what we tried to do for locals during that time was to write, model language under the old rules, which, I mean, that was like a bullet point list that I think was like a page and a half long. And I know we got feedback from a number of locals that was like, well, if it's going to be this, we don't feel like doing it. So we'll just, we just won't do it. The updated language, if you've taken a look at it, is really more like 4 or 5 paragraphs, and a lot of it is, are you using an approved vendor that, that can assure you in writing that they're complying with the most up-to-date guidance from DOL. So it is designed based on how the rules have been updated to actually say you can adopt this and this is livable, as opposed to something that might be so discouraging that you might say we're just not going to do electronic voting.
And speaking of elections, since you brought it up, and we're talking about electronic elections, can you make the distinction of what is required for notifications of elections and how that's
Yes.
different for electronic? Because I think that's a big one that I've been dealing with lately and trying to inform people. No, yes, you can have electronic voting, but notification's still different.
Yeah. So, I mean, even with electronic voting, that has not changed the requirement. It's written in the statute. The LMRDA itself states that election notices must be sent out not less than 15 days prior to the election, and it must be mailed to each member at his last known home address. And then to help make that even clearer, regulations of the Department of Labor say, since the act specifies that the notice must be mailed, other means of transmission will not satisfy the requirement. So, I mean, we hear from locals all the time. Nobody checks their mail. We do stuff by Engage. We do stuff with text messages. You can always do email notification and text message notification in addition to mail, but you have to do the mailed election notice at least 15 days in advance, even with electronic voting, to make sure that you're satisfying the law. And you also have to comply with, other pieces of election law, like the preservation of records for a year. So make sure that all the data and all the things, related to your electronic voting are preserved for a year. If folks do mail ballot elections, I'm happy to get into that. That does, there are special rules where, as long as you have the voting period open for a long enough period of time, the ballot itself in a mail ballot election can serve as the notice of the election. So there's that piece. And then there are also the model language for how we do, nominations notices versus election notices. It's drafted as sort of just a simple thing of, send out election notices and nomination notices, at least 15 days in advance, with by postal mail, but if you really want to fully separate those things and you have them at 2 totally separate meetings, the specific rules on nominations notices are a little looser, so that if you want to just do steps that are reasonably calculated, I think is the exact regulation word, to notify every member by doing things like posting on bulletin boards, putting it in the newsletter, text messages, things like that for the nominations meeting. And you do that, and then after that, you send out, the election notice by postal mail 15 days in advance. You can do that.
Perfect.
Okay.
Any questions on elections or electronic meetings? You can raise a hand or go in the chat. All right. Any other topics, Aaron?
Hey, Stephen.
Yeah, go ahead, Mike.
Hey, I'm sorry. I just had a question on the clarification for that. So my CBLs only talk about a 15-day notice specifically for nominations. It doesn't say a 15-day notice for the actual voting period. So is that something that needs to be adjusted to where I have to have 15 days notice for each one of those 2 instances?
Well, so what I'm guessing is, so let me read you what's in the sample CBL and tell me if this sounds familiar. The sample language that we do is, each member in good standing shall be given advance notice in writing of the date, time, and place at which nomination shall be made, and at least 15 days advance notice in writing sent by mail to the last known address of the member of the date, time, and place at which election shall be held. Does that sound like your CBL?
Yeah, it sounds almost identical, but
Then you're good. Then you're good.
Okay.
Because the whole thing is you're giving advance notice of the nomination and 15 days notice by postal mail of the election.
Okay, perfect.
So that covers. Yep.
Thanks.
Yeah, you're welcome.
And I see quite a few locals on here. So I know a lot of you have done your CBLs, but if you don't know, it's required by the Constitution and bylaws. Every 4 years, you're submitting a CBL. whether there's a change or not in your CBL, has to be submitted through the IFF. So when you ask for resources and I ask your last time you submitted a CBL, that's the reason why. And we're starting to track that a lot more because it is key. And don't be ashamed if your local hasn't done it in a while. I think the record that I've seen while I've been DVP is 1968 was the last time somebody submitted a CBL. So if you haven't done it, shoot it in, even if you have no changes. If you're looking at some changes, you need some language, let us know. We're here to assist. If I can't do it, then Aaron in the general counsel's office has been outstanding at it.
All right, so we got a question. What is the legal cutoff for new members as far as voting? If they happen to become new members less than 15 days before the nomination meeting, are they still eligible to vote? What notification requirements do they have? That's a good question. I mean, well, so the first thing I'd tell you to do is to look at your constitution and bylaw, you know, as far as restrictions goes. I mean, so the LMRDA does allow certain things that say, you know, you can have certain restrictions on people who are brand new, you know, or newly readmitted, as long as you actually put those in your constitution and bylaws and say, you know, while you're a probationary employee, you can't vote as long as that's like no longer than a year or so. You know, just new members or new, you know, can only, you know, be prohibited from voting for the first 6 months or so. But you can't just have that as an unwritten rule. If there was a restriction like that, it would have to be explicitly written in your constitution and bylaw, and we would want to review it and approve it. You know, there's a legal principle called impossibility, and we actually had to deal with this in Canada because they have a mail strike. And, you know, so in that case, right, the statute of US law says you have to do these election notices by mail. And we had to give advice and say, well, what happens if it's actually physically impossible for you to do something by mail, you know, because the Canadian Postal Service is on strike. So, you know, if there's absolutely no restriction on, you know, on new members voting, they just have become a new member and it's just written like that, I would advise that, you know, give them the notice as soon as you can, because that's what's possible. It would be impossible for you to have given them notice before that.
And the answer to your question on updating more than every 4 years, yes, absolutely.
Yes.
You can update whenever you add new language and it's voted on by the members. That's something else that's important. It needs to be voted on by the members before you submit it. You had some locals that were doing it backwards, we found out. Make sure you're not in that boat. Make sure it's voted on before it's submitted.
Yeah, I mean, I think we have some locals that seem to submit every year. I mean, I think they're pretty active in amending each, each year, and they just get it in each year, and we're always happy to take a look at it.
And you said something, Aaron, that reminded me of something that I've dealt with a couple of times now that I think is important on this call as well. You mentioned restrictions, and I had to go excuse myself while I was coughing my butt off here for a second, but if you didn't mention it, we can place restrictions even on people that run for office as long as it doesn't impact a majority of the membership negatively, correct? So we could say you must attend 3 union meetings a year in order to run for office if a majority of your members are making more than 3 meetings, correct?
So the LMRDA rules have these specific types of qualifications that they recognize that are exactly like what you said. It can be period of prior membership, where it says, you know, you must have been a member for a period of not exceeding 2 years before you could run for office. You could have a continuity of good standing that you had to have actually been, you know, paying your dues on. I mean, as you're doing, you know, the electronic, you know, like automatic dues deduction, that's less of an issue. Meeting attendance requirement is exactly like what you said. It's a little complicated because, right, it's for all these things, it requires you to monitor and keep an eye on, like, are you disqualifying a large portion of the membership? This is based on Supreme Court cases from the 1970s, but years ago, it used to be that as long as you had a meeting attendance requirement that wasn't above 50% of meetings, then you were in the clear. But then those Supreme Court cases in the 70s were like, well, we have these 50% meeting requirements, but it's still excluding 75% of our membership or 90% of our membership from being able to actually run for office. So that instead of having a hard number or something easy where you could just say, I'm doing this, I'm definitely in the clear. Instead, it's more like you have to keep an eye on it. And if it's disqualifying a lot of your members, then, then it's no longer reasonable under the law. And you'd have to either ease it, or if you're really having a problem with people attending meetings, then, maybe drop the meeting attendance requirement entirely.
And I think we got another question about if the language isn't perfect, even though it was voted in. And I think that kind of segues into approved, conditionally approved,
Yes.
denied, if you want to kind of cover those.
Yeah, so those are the three categories that DVP Gilman just described of how we get these things out. You get a clean approval letter, means that you've gotten everything in your constitution and bylaw looks great. No notes from us. Conditional approval is something that says here, this has the GP's signature on it. You can use this document, but we are identifying these specific sections and saying, hey, this conflicts with the IFF Constitution or it conflicts with the law, and that's an issue. And please turn this, this is, this needs to be established as a priority. You need to deal with this to make sure that you're not violating the law or creating a conflict that might result in a complicated appeal. And so for those things, it's not just saying definitely, continue as if everything's great with this particular section we've flagged. It means this is an issue and it needs to be addressed, but you can operate with other changes that have been made in your constitution and bylaw. We try not to do the not approved letter that frequently, but sometimes we will see constitution and bylaws that have been submitted that just sort of fail to capture, the basics of what's required. Like maybe it doesn't even address dues, or it just is so wildly out of line and in conflict and has, pages of issues with legal conflicts or the IFF or conflicts with the IFF Constitution, that we will just say this document is not approved and please, fix this as soon as you can.
Awesome.
Yeah.
We're winding down now. We got a little bit of time left. Does anybody else have any specific questions that we have not covered? Aaron, do you have any topics that you'd like to address? Anything else?
I think those are the main ones.
Okay.
But like I said, I'm happy to talk about any other CBL questions folks have on any other topics too.
Any hands, any questions? Go ahead and unmute or shoot it in the chat. And I honestly thought with as many people as we had on the Social Security that this one would be packed because we get a ton of CBL questions. I think it's important too, Aaron, we talked about earlier before everybody jumped on, interpretation of the Constitution and bylaws and whose job that is. If something is silent or has room for wiggle room, whose job is that to interpret?
Yeah, I mean, so the default is, and what it says in the IFF Constitution is that as long as your Constitution and bylaw is silent on it, then your president has the authority to interpret the Constitution subject to appeal. It is possible some locals could, alter their Constitution and bylaws and say that the executive board, votes or does that, or the president in conjunction with the executive board. But you would have in your Constitution and if it's silent, the president interprets it. Otherwise you could write something that, that you have a different method. But that is, the way that the law is written is that unions have a substantial deference given to them about how they interpret their documents. And it's basically, as long as it's a reasonable interpretation. What's unreasonable, you can't interpret your Constitution one way one day and then turn around and have the exact opposite interpretation the next day because it's convenient. But if you're confronted with a problem you haven't had before and your Constitution and bylaw has a gap in it and you need to figure out how to address it, there's room for interpretation, and it's designed to help you figure out how to manage it. It's not designed to, be a complete impediment.
Perfect. All right.
Okay.
Any other questions? We may get out of here a little bit earlier.
I like efficiency. That's what I'm all about.
All right, we're gonna leave it going once, going twice. Want to say thanks to my good, oh, we
Oh,
got
all
one
right, we got
question.
one. If there are changes that are needed or wanted to be made, what is the process? The process is, so you would get a letter from us. Most likely it'd be from Hallie Miracle, or paralegal in the legal department, that is address, that is from the GP Kelly, that just says here your constitution and bylaw is conditionally approved. It will have instructions on it that will tell you, please hold a vote to approve these changes and send it back to us. I will say we have had questions sometimes where a local has said, what if the members refuse to do this? That is, let's have a follow-up conversation about that, because there are certain things where members can't just say, we've been advised that this is the law and we're voting to do something different than that. So in that situation, I would say, please contact the DVP, contact the legal department, and we will work with you to figure it out. But the general idea is that once you've been given a conditional approval letter that just says, now you're aware this is the law or this is the IFF Constitution, there's a conflict with it that needs to be fixed. You should hold a vote as soon as you can to amend it. And just, once people are advised, then they would hopefully vote in order to make it consistent with the law and the IFF Constitution and just get it back to us. And I can also add to that, we've gotten questions from locals that have said, our Constitution says we only hold a meeting once per year where members can bring up, constitutional amendments. Does this mean we can't make these changes until that once annual meeting? And we can look at the Constitution and bylaw language with you. I've yet to see one yet that was written in such a way where it seemed like that was required. It seems like it's fairly reasonable to interpret and say that there's a big difference between you getting advice from the international that you have a legal conflict that you need to resolve quickly, which could be done at the next meeting that you can schedule it for, versus something that just says this is the once annual time where members are able to bring an amendment from the floor. But yeah, those constitution and bylaws are emailed to constitution@iff.org. And then you get in the queue. And if, you need to check in on the status with it, please email the DVP, check in with us. And also let us know if you have something coming up that's, where your CBL needs to be expedited. Like if you have an upcoming election and there's been a change and you need to make sure that the change gets done before the election, where we make sure to prioritize those. We want to help you.
All right. Well, hopefully this was helpful for everybody. If nobody else has any questions, we're going to let the general counsel's office get out of here. Our good friends, DVP Dix from the 12th and DVP Glenn from the 11th jumped on to see how we were doing our coffee talk. Thanks for joining, Walt and Mike. Appreciate it. Always great to see you guys. And as far as everybody else, we'll get this put onto the website. We'll get this put onto the YouTube channel, and we'll get some, model language associated with that. And again, if you guys got any questions, anything you need addressed, constitutional bylaws or anything else, just make sure you reach out. And Aaron, thank you very much for taking the time today. I think this was incredibly helpful. Like I said, I'm really surprised that we didn't have more than 100 than last time, but I really appreciate the time.
Yeah, thanks so much. It was really great to be with you guys today.
Yep. All right. Thank you, everybody, and we'll talk to you guys soon.
Thanks, guys.